The doctrine of res ipsa loquitur, meaning the thing speaks for itself, allows for a finding of negligence when it's difficult to pinpoint the exact cause of an injury, but it's clear by the nature of the accident that it wouldn't have occurred in the absence of negligence. The 1967 case of Boyer versus Iowa High School Athletic Association shows how this doctrine can help plaintiffs build their cases. Marian Boyer, her husband, and another couple attended a high school tournament basketball game together at Roosevelt Junior High School in Mason City, Iowa. They were seated on the top row of the gym's collapsible bleachers. The game was close and exciting, and by the end of the game, all the spectators in the group's section were standing on their seats. Mr. and Mrs. Boyer and the other couple had to stand on their seats as well to be able to see the end of the game. As spectators left the stands after the game, the section of bleachers that Boyer and her group were on collapsed and folded back against the wall. The other woman in the group was able to stay on the top bleacher, but Mrs. Boyer and the other man fell to the floor, and Mr. Boyer was stuck hanging from the bleachers by his foot. The area the group was on was the only section of the bleachers that collapsed. The bleachers were made of wood and steel in large sections that could be pushed back against the wall when not in use. The 7 rows of seats folded back to a near vertical position, and it normally took about 3 people to push the bleachers against the wall. Throughout the school year, the bleachers were pulled out and folded back multiple times a week. Marian Boyer sued the Iowa High School Athletic Association, which managed and directed the basketball game, for both specific acts of negligence and res ipsa loquitur. The trial court withdrew the specific negligence charges, but submitted the case to the jury on the doctrine of res ipsa. The jury found for Boyer. The Athletic Association appealed.